take this opportunity to share the CLE code with the participants that are coming into the room. The CLE code for today is 8549. Again, that's 8549. And it will be for the Circular 230 and Ethics and Tax Practice CLE. A reminder that the tax section's monthly free CLE series are typically available on YouTube. All prior sessions are available on YouTube, and these are typically, the links are circulated on the periodic newsletter sent by the tax section CLE. All right, I'm going to start with a short bio of our speaker today, and then I'm going to announce a few upcoming tax section activities. Michael Lampert. Michael, we are happy that you are with us today. Michael is a Florida Bar Board certified tax lawyer in private practice in West Palm Beach at a tax boutique, where he concentrates his practice in the areas of taxation, business, and estate planning and administration, with an emphasis on tax controversy matters. He is a he's a fellow of the American College of Tax Counsel and a past chair of the Florida Bar Tax Section. Thank you for joining us today, Michael. We are excited to have you. And if you would just give me one moment, I did want to share a few upcoming events at the tax section of the Florida Bar as we give our attendees another minute or so to come in. So the tax section will have its next free CLE for tax members on August 21st, Wednesday, August 21st from 12 to 1. And it'll be a live Zoom, just like this one. Andrew Weinstein of Holland and Knight will join us to discuss litigation of federal tax disputes in bankruptcy court. And on October 24th through the 26th, the tax section will have its fall meeting and the Tax Attorney of the Year dinner honoring James Barrett. It will be held at the Margaritaville Beach Resort in Hollywood Beach, Florida. And in January, we have our 10th annual ITC Boot Camp and the 43rd annual International Tax Conference, which is always well attended. So I will now pass it on to Michael Lampert, and I encourage you, if you have any questions, to please add your questions to the chat box. There's a Q&A box. And as well, Michael, you can decide whether you're able to answer the question during each session, or if you want to wait till the end to answer your questions, but I leave it up to you.
You all can just chime in unless it's getting out of hand, then I'll try to get to it at the end.
Right.
Plus, most of you know who I am anyway, so you can always ask. Yes.
I'll have my video off. If I turn it on, it could be that, you know, there's a question in that particular section that I think would be, or usually within about 5 minutes, and when the CLE ends, I'll also turn on my camera and we can address the Q&A there if you haven't been getting to it throughout. Sometimes the speakers, the Q&A doesn't always pop up for the speakers, so I may just be answering if there are administrative questions regarding the PowerPoint, etc. I can answer those, although Whitney, you've dropped those in the chat, so everybody should have those. And if anybody has any suggestions for future tax section CLEs, please reach out. My name is Jennifer Migliori. I'm the Assistant Director of the Education Committee of the Tax Section of the Florida Bar. My email address is in the chat. jmigliori@dwaynemorris.com, and I am going to pass it off to our speaker, Michael. Michael, take it away.
Thanks. Good afternoon. I'm assuming that a bunch of people need ethics credit, which is why I see all these people that are on it. Hopefully, some of you are planning to take the certification exam. I've done 2 6-year terms. I rotated off after being chair and then past chair of that about a year or so ago, so I have a little familiarity of it, and I was generally the one who wrote the ethics questions that went on to the exam. So hopefully, well, I can't say what questions were. Hopefully this will be helpful. Like a lot of presentations that I do, we're likely not going to get through all the materials. You've got 3 sets of materials. And for those of you who went and did the LLM tax program at UF, some of the materials will sound familiar. The main set of materials are that big packet, that outline. The second thing is there's a little 1-pager of my 13 ethics concepts. And the other item is a PowerPoint presentation. Now, a word about my PowerPoint presentation. Before I did my annual pilgrimage to Jamaica, about a week and a half or so ago, we just got back this weekend. The materials were sent in. Well, we had the materials ready, except for the PowerPoint. My assistant did the PowerPoint. I will take the blame for anything. However, as I was preparing for today, I discovered that there were a couple of typos. So here's the deal I'm going to make. By close of business tomorrow, anybody who comes up with the most number of typos and miswords and things like that, and I don't mean grammar errors, will get a gift of my choosing. And so I don't have to go through all the rules, much as I raised my 2 sons. I reserve the right to be arbitrary and capricious in determining who actually won, because I don't have Kristen here to actually act as the adjudicator. So on that note, I'm going to go ahead and share my screen. And hopefully you now see the screen. And we are going to, get going from there.
We
All
can
right.
see the screen, Michael. Looks
So we're
good.
good.
Yes.
Yes, thank you. All right, the PowerPoint is really more so we can move things along. And I'm going to try to talk a little bit about where a lot of the regulations that govern tax practice. Second, in there, I'll talk about Circular 230 and some of its impact and some other related items, and a couple of the basic ethics rules that I think particularly impact on the practice of tax law. And then I'm going to throw a few potpourri items in there, and we'll then run out of time and we'll kind of go from there. So here we go. If it starts, it didn't move. Let's try this again. There we go. All right, first of all, where do we get the guidance for tax attorneys? And if you think about it, tax lawyers are different. And I like to say it's because we're smarter. I think that's true, but a few other specialty areas probably have some reasonably bright lawyers. And it's not because there's so many different regulations in terms of the law. Because if anybody has done environmental and land use planning, we've got, I think, 39 municipalities in Palm Beach County alone. So that's what, 39 sets of zoning, plus the county, plus various water districts and whatnot. So it's not that we have more areas of law. I think the difference is we've got more entities that purport to tell us what the rules are. So let's run through a few of them. First of all, you got the Florida Bar, and many of us are also admitted in other jurisdictions. And remember, those jurisdictions have their own set of rules governing practice. And Florida's has an integrated bar. What integrated means is that the general things, such as the sections and a lot of that general CLE and all of that, is part of the same bar that actually regulates attorneys. Some states, such as Pennsylvania, were admitted, they're separate. So you don't have to be a member of the Pennsylvania Bar Association to be admitted and licensed to practice law in Pennsylvania. So we've got these rules that are out there. And keep in mind that the rules are different in different jurisdictions. So you could actually violate a rule in one jurisdiction, get reciprocal discipline in your home jurisdiction, even though you didn't necessarily violate a rule in your home jurisdiction. So keep that in mind. In addition, increasingly, we're doing a multi-state practice, and you may run into a situation where even if you're not admitted, and maybe you should or should not be practicing in that other jurisdiction, depending on what you're doing, but you could find yourself subject to that state's bar rules. So be careful there. The second thing is the ABA. If you ask the general public, all lawyers are governed by the ABA. The reality is now it's about 17.5% as of, I think, last year of lawyers that are members of the ABA. And 20 years ago, it was probably in the neighborhood of half the lawyers. So it's going down, but it's still a bully pulpit. They've got model rules and model code. Model rules are the ones that Florida substantially follows, as do many other jurisdictions. They issue advisory opinions, and they're a heck of a bully pulpit. There's also, and here's my first little word that I want to correct in here, It's other non-mandatory bar groups. There's usually not a lot of mandatory groups, but there's a lot of non-mandatory that have various rules or procedures that you should be following. For example, in Palm Beach County, we have rules of professional courtesy. And when a lawyer is violating them, sometimes you get a letter from the other lawyer saying, hey, look, you're violating our local rules of professional courtesy, and kind of threatening to tell the judge if you don't behave. So they're out there. Then you've got Treasury and the Internal Revenue Service that obviously have a whole pile of rules. Now, I want to remind you that the Treasury rules are fundamentally not Title 26, which is the income tax code, but rather Title 31. And Circular 230, which hopefully you're all familiar with, and we'll talk a little bit more about it shortly, is a regulation. It's a Title 31 regulation governing practice before Treasury. So kind of keep that in mind when you're looking things up. In addition, of course, the Internal Revenue Code has prepare penalties in there. It's got aiding and abetting penalties, civil penalties, criminal penalties. So those also govern what it is that we do. In addition, realistically, ignoring state level, you got 4 federal courts where you can litigate tax cases. Tax court's the one we think of. We've got the claims court, district court, and of course, bankruptcy court, where you can also litigate tax cases. So we're subject to all those rules. The AICPA, many tax lawyers are also constant pains in the CPAs, and you have the state CPA groups as well as the state CPA licensing authority. Depending on the state, they have different divisions or departments that do that. So again, the CPAs that are practicing as lawyers still need to be following those CPA rules. And if they get disciplined as a CPA, it could theoretically or potentially lead to discipline as a lawyer. You also have the Florida statutes. The Florida statutes don't have a ton on really practicing rules, but it does have some not so clear ideas of what the unauthorized practice of law is. In certain areas, they are authorized. For example, real estate agents, brokers can fill in blank contracts. It's an authorized, although unlicensed practice of law, if you will. We also have the administrative code. What's interesting about that is it excises out lawyers and law students that are practicing under a lawyer, but it talks about otherwise practicing before state agencies and how others can potentially be allowed to present before state agencies. We also have malpractice and civil liability. And I've gotten in debates with people as to whether, and I'm going to use the term simple malpractice, is actually grievanceable because you didn't practice competently. And arguably, any of malpractice is potentially grievanceable. I don't always see one leading to the other sometimes, but not always. Kind of depends on what it is. You could probably write a nice paper on that. And the other one I'm going to add in number 11 here, and that is non-US. Increasingly, we're dealing with not only multi-states, but multi-countries. And I want to remind you that a lot of countries don't have the same concept of attorney-client privilege that we do. So if we're working with a non-US attorney, they may not have the same privilege protections, or more accurately, their client, your client, may not get the same privilege in communications with that non-US attorney. In addition, there's a lot of disclosure rules. In the United States, for example, the requirement to do Form 8300s if we get $10,000 or more in currency. Other countries have even more disclosure to the government by attorneys. So you've got to be sensitive to that. And remember also that you could be long-armed, not just by another state, but theoretically by another country. So be really, really careful with that one. And you could inadvertently do something you're actually breaking the law in another country, and then the US could help enforce that foreign law violation. So be careful with that. All right. Again, I've got this in the materials here, but this is the basic statutory authority that's governing the practice before the Treasury, of which the IRS is part. This concept always sort of bothered me. Imagine if they had a similar thing for criminal defense lawyers practicing before the FBI, where you could be disbarred for practicing before them for so-called improper behavior, which is a real trick because there's not a bar to be disbarred from, but they use the term anyway. But this code section and the regulations that go along with it talk about monetary penalties, disbarment, suspension, censure, private reprimands, more formal reprimands. It deals with regulations for appraisers. It's got standards for written advice, a lot of things like that. So it's floating around out there. And then, of course, Circular 230. And again, it's referred to as a standalone, but it is nothing but a regulation. And it talks about the rules to practice before the Internal Revenue Service. Now, Treasury, more specifically the IRS, has been trying to reach and do more to, I'll say, grab control, if you will, over tax return preparers. Because those of you who do controversy work know that there's a lot of bad preparers out there. And I don't mean just bad incompetent, but I mean they're just doing bad things. It's like out of True Blood. They're just doing bad things. They're making stuff up and they're just bad. And Treasury, Department of Justice tries to stop them, but it's bad and we get to clean up the mess, those of us who do tax controversy work. And you'll see on the next slide here, where was it? I think I skipped a slide here. The other piece to this is it sets up the Office of Professional Responsibility, OPR. That is the department that ultimately disciplines practitioners before Treasury, attorneys, CPAs, enrolled agents, and to some extent, appraisers that are qualified to present to, for the IRS regarding their appraisals. So that's floating around out there. They're the ones who do it. Now, that is separate from penalties that a preparer or a practitioner may get for violation of the Internal Revenue Code or regulations for bad returns, for aiding and abetting, and all those other fun things. So kind of keep in mind how that thing floats. Best practices. Within the whole Circular 230 gamut, there's a pile of what are deemed to be best practices for tax advisors. And I think most of these are pretty obvious to most of us. But if you take a look at it, communicating clearly with the client, I mean, that's us for tax lawyers, that's for everybody. Establishing facts, determining the relevant facts, the reasonableness of assumptions, and that's a big item, by the way. I'll get back to that in a moment. Coming up with conclusions that are supported by the law and the facts. It sounds like a law school paper. Well, I think we'd all agree to that. Advising the client. There's a little more emphasis here talking about how they can avoid accuracy-related penalties. Well, unfortunately, a lot of clients come to us and all they really want is a get-out-of-jail-free card. In other words, they want to push it to the line. They want to get over the line. They want something in writing from us to try to avoid penalties. And I'm regularly telling clients that anything I write is not binding on the service. Yes, if I think that they're simply trying to get out of penalties, chances are I won't do it. You all have to make a decision within what you're willing to do and what your law firm is willing to do. And of course, act fairly and with integrity and practice for the Internal Revenue Service. Many of the people that we deal with at this service, I think, do that in return, but I think we'd all agree that maybe that doesn't always happen. And there's some other things in here within Circular 230 should be aware of. Exercising due diligence, not unreasonably delay. That is something the service does regularly, unreasonably delay. You'll see D&E in here, much like there's limitations on practicing with the disbarred attorney. You have a similar thing if you're doing IRS work with somebody who's not allowed to practice before them because they've been suspended or disbarred. And again, it's not a bar to be disbarred, but that's what they call it. And we're supposed to tell our clients upon discovery of an error or failure to comply with the tax laws. And that's kind of an interesting one. Obviously, if you're on an active case and you see it, you're going to tell them. But what about 6 months from now, 2 years from now, 3 years from now? Remember, a lot of Circular 230 is addressed not just for lawyers that are advising and doing transactional work, but also they're doing tax returns. So keep that in mind. For some reason, they don't want us acting as a notary on specific matters. Now, I mentioned before, you can get conflicts between, for example, different state bars. Well, you have an issue here because there's a couple of rules within Circular 230 that clearly violate the Florida bar rules. And I suspect virtually every other state bar rule. First one is charging an unconscionable fee. Now, for some of us who, as I've gotten older, I like to travel more. I'm not exactly sure what an unconscionable fee is. I mean, I say that sort of tongue in cheek, but clearly that's not the Florida Board rule where you're really not supposed to charge an unreasonable fee, and we could debate what that is. So you could file Circular 230, be grievance at the state level, and the reason why we can practice for the service without any further exams is because we're licensed to practice law in Florida or whatever jurisdiction you're licensed in. So you've got this banging where you might be following one set of rules, but be disciplined for another. The second is representing conflicting interests before the service. Well, that sounds obvious, except if you look at Circular 230, all conflicts are waivable with disclosure, written disclosure, well, written consent. You got to have a writing, if you will, to the client. All conflicts are disclosable, or excuse me, are waivable. Clearly, under the Florida bar rules and probably virtually every other state bar's rules, all conflicts are not waivable. So once again, the service may be okay with it. And interestingly, and it's not in your materials, theoretically, the service can ask to see that conflict waiver. I've got real issues with that. I've never been asked to do that. Every once in a while it's come up. The concern that I have with the waivers is if you're doing a waiver, you've tried to explain the reason. And sometimes by explaining the reason, if the service sees it, they're going to better understand possibly some of the weaknesses in your case. There's certain size of restrictions on advertising, and they're misleading, and solicitation, and not negotiating refund checks. Again, most lawyers don't do this. It really tends to be more the preparers who do this. And if you're doing tax shelter opinions, for those of you who still do them, there are more restrictions on that. Written advice. This was, and some lawyers still have this on their footers about this is not tax opinions. I've seen people give legal advice and tax advice in an email, and then at the bottom says, this is not my advice. When that came out and this OPR and Treasury and the IRS came out and tried to talk about what you should be doing when you're giving written advice, it led to these footers on footnotes saying, we're not giving legal advice, and we're not giving tax advice, excuse me. And I talked to Karen Hawkins a number of times about this, who was the head of OPR at the time. It was just one of those unintended consequences. She didn't understand it. She said that wasn't what it was supposed to be. Lawyers still tend to have it on there. I understand in a lot of larger law firms, you didn't want the litigators and divorce lawyers giving tax advice, but I see it on footers by tax lawyers. You just don't need it. But you are supposed to have reasonable factual legal assumptions, reasonable reliance. This is a big deal because when you look at some of the opinions and some of the advice that lawyers give, clearly, if we have an appraisal and we're using that to base our opinion on, that's fine. And there may be something that you're trying to judge, but you went to a specialist in state tax law or international tax or something, and they're giving you that. And you're basing part of your opinion on what they're telling you. That's okay if it's reasonable, but don't run into a garbage in, garbage out. People were taking bad appraisals. They were getting letters from CPAs and lawyers that you could just read it and you couldn't even read it with a straight face, but they were relying on it. So be really careful. It's okay to rely on what other people are doing in what you're doing, but it's got to be reasonable. Now, the other piece is clients always want to know, well, if I do this, am I likely to get audited? And you'll see articles about this, about, well, you're more likely to get audited if you do X, Y, and Z. And my attitude on a lot of it is, all right, if I get audited, fine, I'll pay my mortgage that month and I'll deal with it. But what you are not allowed to do in giving an opinion to say, look, even if we're wrong, you probably won't be audited. We're not allowed to do that. But we can say that if you get audited, my experience, or I would expect that we would be able to resolve this successfully in settling it, say, with appeals or in litigation. And that's okay. All right. If you violate it, I've mentioned this before, you can be disbarred, suspended, monetary penalties. The other thing I want you to be aware of, some of you that are more senior, if you are a supervising attorney in a firm or a supervising accountant in an accounting firm, you could potentially be disciplined for what your subordinate did. Okay, so beware of that. And keep in mind also, separate from Circular 230, there are penalty provisions in the Internal Revenue Code. And I mentioned about OPR. A lot of people are not aware of enrolled agents. You may have heard the term unenrolled preparers. Attorneys were, in a sense, enrolled. We can practice for the IRS. CPAs are. Enrolled agents, if you ever look back at the history of it, it actually started after the Civil War when people were making claims for compensation. And they came up with these enrolled agents that were allowed to do it. And when the tax code came into being, somehow it morphed into doing tax prep. Enrolled agents tend to either be retired IRS employees that had significant tax facing things. In other words, they weren't the IT people, or they can take 3 fairly difficult exams. For those of you that are solo and small firm, I can tell you that my now law clerk, my long-term legal assistant, she's now in law school, which is why she's now my law clerk. A number of years ago, I encouraged her to get her EA. I paid for the review course. You're always welcome to touch base, and I can have touch base with that. As a solo, having an enrolled agent on staff has been awesome because she can also interface with the service. And interestingly, as an EA, much like a CPA, she can also interface with state departments of revenue. And for things that non-lawyers can do, it's been a blessing. I can't say it any other way. You also have unenrolled preparers. They're the ones that don't fit that, and they're regulated by small business self-employed. In addition, as you'll see in a moment, there is now this other office, and we were really worried that they were going to try to regulate a lot of things that OPR does, and I haven't seen that actually happens. All right. And that is the Return Preparer Office. They deal with the P10s. For those of you who don't know, P10, for those of you who actually do tax returns, and yes, that includes 706s, you need a P10. That is separate from your CAF number, your centralized authorized file number, which is when you submit powers of attorney or information authorizations. Okay. The service has been trying to regulate unenrolled preparers more. They have not been successful. They likely need a legislative fix for that, but they do have this thing called an annual filing season program. And what that does is it allows tax return preparers that are unenrolled to handle the audit, not further, the audit on tax returns that they actually prepared for a taxpayer. So that's out there. I do want you to be aware of that. You may run into that. All right, let's take a look at some of the various bar rules and how they interface with what we're doing. First of all, the duty of loyalty. And that, to a large extent, is what we might have thinking of as conflict, because we have to be loyal to our client. And therefore, if we're representing more than one person, and remember, you got more than one person, you have a potential conflict. With a few of our clients, with their personalities, just having one client, you feel like you want to have them sign a no conflict letter, depending on which personality they show up with each day. But think about it for a moment. For those of you who write no conflict letters, in other words, those waivers, we're supposed to make a knowing disclosure. In other words, that they can make an informed decision. For those of you who know attorney Jerry August, who is, first of all, he's an awesome tax lawyer. He's one of those guys that can also cite like S Corp subsections and whatnot. But a number of years ago, when family limited partnerships, flips, were all the rage, he came up with Jerry's top 10 rules for flips. And his number one rule was don't do flips for stupid clients. And I understood what he meant, which was if they can't understand what it is, they can't understand the risk. Well, think about it here when you're trying to do a no conflict waiver. Do they really understand what it is that they're waiving? I have a general rule of thumb, and rules of thumb are dangerous. But that is, if it takes me more than a page to do it, other than who I'm directing it to and the addresses, I probably won't do it because it's just too much detail. So everybody's going to have their own rules on this, but be careful. But again, you still have to reasonably believe that you can competently represent them. We do this in estate planning for 2 spouses all the time. Regularly, you'll have a couple people coming in, they want to do a business transaction, and you have to discuss with them the potentials for a conflict and be clear of it. But the second piece I want to be clear on And this is absolutely critical, and I'll likely stress it later in this program also. And that is when you have this duty of loyalty to a client, you need to know who the client is. And it's not just who gets the bill. We'll talk about that in a moment also. But you've got to know who the client is. And not only do you have to know who the client is, you need to know, and the non-clients need to know who is and is not the client. For those of you who do estate administration, one of the form letters you will often send out to the beneficiaries is, I represent the personal representative. That is where my duty lies. We do not represent you. So you're clear. Does the PR and therefore the attorney have some duty to try to do it right to protect the beneficiaries? Of course they do, but they don't represent the beneficiaries. You've got that issue here. You've got to be really clear who you represent, who you don't represent, and make sure the parties involved really understand it. The other piece is, and those of you who are at Ullman, at the Ullman Year in Review on my ethics presentation, the ethics bingo, I put a case in there that was interesting. This guy got disciplined. First of all, he got disciplined because he did a lot of other bad things, including stuff he said to the grievance panel. But the underlying grievance was that he did his waiver and his fee, well, he did his fee agreement to his client in English. His client didn't understand English. His client spoke Spanish, and he got disciplined. Now, I suspect if that's all he did, that might have been able to be resolved, but he did a lot of other not nice things also. So again, conflict here, this talks about it. There's more information between the slide and in your materials. You also need to be careful, okay, is do you do deals with a client? In the olden days, when you had all these tech startups, and I know this still exists now, lawyers would often take a piece of the deal. Much like all the other employees, they took a piece of a deal. They worked for very little money, slept on mattresses on the floor. But some companies, the Facebooks of the world ended up doing very well. The dilemma you have when you take a piece of a deal is you've inherently made a conflict. On the one hand, you want to work extra hard so that your ownership interest in that entity does well. On the other hand, you might want to advise that business, you know what, I think you need to shut down, or I think you need to do this. It's in the best interest of the business. The problem is if you do that, it might interfere with the value of your ownership interest. So you create this conflict. And the same way where a client wants to sell you, you're handling an estate, or you're doing something, or you're selling assets, or you're trying to come up with some cash, and you look at it and you realize they're about to fire sale an asset, you'd like to buy it. I like to do, for those of you who get the reference, I like to do a Nancy Reagan and just say no. And I've had a number of those. The one that I really regret to this day I didn't do is I had a client that had a wet submarine, and I almost took it as a fee. Their kids had moved out and was just sitting there by the side of their indoor pool. But be really, really careful with this, okay? Another little tip I would make, and I think it's important, and I'm going to mention it here. For those of you that are solo and small firms, you see your malpractice application. They ask questions like this. Are you on clients' boards? Are you on nonprofit boards? Do you do transactions with clients? You'll see those questions. For those of you who are more senior lawyers in larger firms, you're obviously not giving your full malpractice application with all of your financial information to your baby lawyers, to your newer lawyers. My suggestion is sanitize it and let them see the application, because this is what the malpractice carriers consider risky. And if, as part of your education to your younger associates, they see that, it might realize that they're not just hearing it from a more senior lawyer, they're seeing it from the malpractice carrier and what that law firm has to deal with. Likewise, gifts to lawyers or lawyers' family, you're not allowed to do it. The rules now in Florida are very clear in terms of preparing testamentary gifts or things like that, unless they're family members. So be really, really careful there. Compensation by third party. This one, be very, very careful. I run into this all the time. I bet I run into this almost weekly. The classic example, of course, is kid gets arrested for drunken disorderly, doing something stupid. Parent shows up to court with the kid. Parent shows up to the law firm. Parent pays the lawyer, all that good stuff. Well, point is the lawyer is representing the kid, not the parent. So the kid's got to understand and give consent, which obviously they're going to do. But what about in our practice? Well, I have a heavy controversy practice, and it's not uncommon for a family member to pay our fee or to have a business pay the fee for an individual. I do a lot of penalty defense. I've got piles of these offshore penalty cases and FERPTA cases, and I've got ones where I may be before the service representing the taxpayer that's getting penalized, but the title company, the lawyer who acted as the closing agent, or the malpractice carrier, or the title company is the one who's actually paying me. They're paying my fee. So I've got to do this disclosure to the ultimate taxpayer that somebody else is paying my fee. Now, usually they're very happy about it, but you've got to be really, really careful there in terms of where your fee is coming from. So again, this is one that's not talked about a lot, but I urge you to be careful with that one. Sometimes client will say, yes, I'll send you a retainer check or I'll call in a credit card, and it's not their credit card. It's not their check. It's coming from someplace else. Now, if they're the ones who mailed you the check, maybe I have a little less discomfort, but be very careful. Conflicts of interest, former clients. Just because they are a former client doesn't mean that you can take on new things that conflict with them. Okay, it's that simple. The other comment I'd make here is sometimes they're not even former clients. We have a list in our office, and it's not perfect, but everywhere where I am listed in an estate planning document, everywhere where I'm listed in a contract to receive notice, all of those types of things, we try to keep a list. Why? Because arguably, even if I close that file and do a nice closing letter, I'm still listed in that document. I'm still listed to receiving notice. For those of you who are still serving as registered agent, do you periodically check? For those of you who have a lot of cases in the CAF, the centralized authorization file, with powers of attorney and information authorizations, do you do hygiene with that? Periodically get that list and get them out, because you may find that this former client, of which you potentially have a conflict with, is not even a former client. They're still a client, even though you don't even realize that they are. Because rest assured, if there's a problem, a plaintiff's lawyer representing your now former client will point out that you are still their client. Still their attorney. Be very, very careful there. Also, just because they're dead, and I have a slide on this, but I want to mention here, just because they're dead, all of these rules still apply. So be very, very careful with that. Next slide. Informed consent. You want to confirm the informed consent in writing. Many lawyers get the signature from the client, but theoretically, the lawyer can just write that letter, do that email, confirm it in writing. You have a couple things in here. One is where how do I describe this? Client wants to avoid penalties. They get an opinion from the lawyer. They rely on what the lawyer says. Okay. Now, the client, if it's reasonable, often will now be able to avoid some negligent substantial understatement penalties. But the service can still come after the practitioner, because the practitioner needs to be protected by doing a disclosure. Well, the client might not want to do the disclosure. So you end up with this conflict there between, do you do the disclosure to protect the practitioner, while at the same time it's not necessarily necessary for the taxpayer? Keep that in mind. You also have joint returns. Now, most of us don't actually do income tax returns. I suspect there's a couple on this call who might. But what happens is we're advising on these things. We're advising the aftermath. And anytime, again, you've got two people, what you do for one could put the other one at risk because of joint and several liability. So you've got those types of things that float around out there. But let me give you some others. Hopefully, you get referrals. You will get referrals from CPAs. You'll get referrals from insurance and other financial services professionals. You meet with the client. There's things that are confidential that you don't want to be able to tell that agent, that accountant. That agent, that accountant who sends you a lot of business is not happy with you because you won't tell them what's going on. And you know what? You've got to just suck it up and acknowledge that. You also run into reverse conflicts where, to protect themselves, the client will turn on the practitioner. So keep that in mind when you're doing some things. So be careful there. Again, my rule of thumb, and rules of thumb are dangerous, is anytime you're dealing with more than one person ever, you've got to watch for conflicts. Cardinal rule, dueling of loyalty. Always know your client is and to whom you're rendering the legal services to, and if you're going to write something else on this page, and who you're not, and make sure that they know who that is. All right, what about confidentiality? Okay. You're supposed to disclose if it's committing a crime or serious bodily harm. The bodily harm, that makes sense. The committing a crime, that one I'm not so sure. If somebody says that they're going to go ahead in Coral Gables and paint their house a color that doesn't meet the color scheme for code enforcement, I don't know that I would be turning them in. But there's a whole lot of maze down here. Again, I don't run into the must very often. I have periodically had clients threatening to go down and do some bad things to the service. And usually when I make it very clear to the client that I will pick up the phone and call TICTA, I love TICTA. They usually back off and say, oh, no, I'm only kidding. I'm only kidding. And if I don't hear it again, so far I've been okay. But you may, it's kind of presumed that unless the client tells you otherwise, some of the basic things that to do your representation, you've got to disclose, it's kind of assumed. If a client comes after you, you can disclose, but you just disclose enough to protect yourself. The idea is if you're going to do a disclosure, you don't disclose everything. Another, here's my file, but rather you pick out specific things that you need to do it. Obviously, if there's court orders, things like that, or you need to do it to follow the bar rules, you need to do it. I have in situations where somebody wants to get some confidential information and I don't really care, particularly when I have a client who died, I will just say, go get me a court order. I'm not going to fight it. I don't care. You don't need to serve me. Just get it to me, send it to me, and then you come look at the file. And when I say it that way, they go get the order and it comes, easy to do. You can, of course, appeal those types of things. But again, you only want to limit it to what you need to do. Now, this new bar rule you need to be aware of. We could do an entire presentation on it. Better, the elder law section, of which I do some things with them. This is really important because it talks about how you represent clients with diminished capacity and what certain things you're allowed to disclose. The fundamental concept of it is that you're supposed to try to maintain as normal relationship as you can, but it acknowledges that at times you may have to speak with third parties. You may even have to go so far as to possibly try to do a guardianship. Former client and dead client. The confidentiality duty continues. Okay. I can't tell you over the years how many times I've gotten a call from the kid or second or third or fourth or fifth marriage, spouse dies. I did the estate planning. One of the kids from the marriage and a half is taking over. They get a lawyer and they want to see what the documents say, or it was a prior client. They've moved somewhere and they want to see my notes and they want to see all of that. And sorry, no. Get me an order. Arguably, once they're personal representative, they can see certain things, but I've had clients flat out tell me about their paramours and whatnot, and they don't want me disclosing that. And you need to be careful. Just because your client died doesn't mean the privilege goes away. Be careful. Circular 230 does not talk specifically about confidentiality. It talks about privilege. And I want to be clear about something. Privilege is an evidence rule. Confidentiality is an ethics rule. Confidentiality is our duty to keep our mouth shut. Okay. don't talk in the elevator, all that good stuff. Privilege is an evidence rule. And one of the things that we run into is, for example, CPAs, they may understand the concept of confidentiality, but they didn't take evidence in CPA school, in accounting school. And privilege, if you're not careful, you can blow it. And you need to be very, very careful when you're dealing with that. So the service acknowledges it, although they kind of conflate the term confidentiality with privilege. So you've got the attorney-client privilege. First of all, remember, it's the client's privilege. It's not our privilege. It needs to be made in confidence. And in the tax area, particularly the controversy area, they're regularly bringing in family members and friends. And it can blow the privilege, not because we then get to talk about it because they're in the room and therefore we can breach their confidentiality. But theoretically, they could be subpoenaed. And unless it's a spouse, they might have to speak. So in some situations, I'll write a letter, but almost like covelling, and I'm trying to include them. In a lot of situations, I will do an interview looking for criminal indicia and whatnot, and then I'll bring the person in. But in a lot of cases, if I don't have that family member or friend helping, I will never get the case done because they're train wrecks. The client's a train wreck. And if I don't have that new significant other or family member helping or sometimes translating, I can't get the case done. So keep that in mind. Be very, very careful there. Also, there is, as a general rule, no privilege for return preparation, which is a reason why, for example, my non-filer cases, I don't do 1040s. First of all, the fee would be stupid. It'd be through the roof. Second of all, there's no privilege for it, to the point where every once in a while, when we have some cases, we will hire the CPA or the enrolled agent. They will do the returns as pro formas. We will review them. We advise the client. Then they take their bat and ball, their materials. They go to a new CPA to actually have the returns that are going to get filed, so that all the things that I did with the CPA to get my pro formas are still confidential. Okay. One thing that you can also run into here is you advise the client. Client follows that advice. Client then wants to avoid penalties by showing they had reasonable cause, reasonable reliance on the practitioner. The problem is, to do that, what do they have to do? They've got to show the service the advice. When they've done that, they've essentially, if they're not careful, waived the attorney-client privilege. So you've got to be really careful in some of these things. So sometimes it's one of those situations where be thankful, careful what you wish for, because you might get it, which is you avoid the penalty, but now you've given them everything. Now, the IRS, they are not a tribunal, at least according to the ABA. They are entitled to the same duty as you give opposing counsel. Now, keep in mind, you're not allowed to lie to federal agents. So, be careful. You've got the normal things like that, but they're not a court where, for example, the court's presumed to know all the law, but then you have to remind them what the law is. You may think it's good tactics, and it may well be in a given case to remind the service what the law is, but sometimes their understanding of the law is in your client's favor. And while you might have to remind the judge, you don't necessarily have to remind the Internal Revenue Service. So keep that in mind. Zooming right along. Other things. There's a couple code sections here. If you knowingly or recklessly disclose return information, what's happening is, and I think the FTC surprisingly just went after some of the big tax prep firms, because they're taking the return information, data mining it, and then trying to solicit them for clients for other work. So I don't think law firms normally do that, but keep in mind that there's limitations on that, but it generally is on the person who prepared the return. I've sometimes tried to use this when I get involved in divorce cases with tax issues, but I don't usually get too far. 8300, when this thing came out, this is the cash reporting. Lawyers were saying, wait a minute here, I shouldn't have to do this because I'm disclosing. There is possibly a little bit of a carve out if there's a direct link, as I note in the materials here, of disclosure of the client's identity, that it would, basically give everything for that crime. But fundamentally, we have to do 8300s. I have had to do them every once in a while. Sometimes we're trying to gather money to pay the service. I've got clients selling assets. They'll take some equipment. They'll go to one of those auction houses. they'll sell the asset, they'll get the receipt, they'll get a check, and then instead of just endorsing the check to my trust account, they go into the bank, they cash it, and they show up with $20,000, which I then have to give an 8,300 on them. I then have to deposit in my account. My bank then reports me either with a SAR or something else. And that's a suspicious activity report. Although I think with me, they know it's not so suspicious, but they have to report it anyway. And it is what it is. But be sensitive to that if you are dealing with currency. And when clients show up with $9,900 in currency, keep that in mind. This one is, there is a privilege, but for preparers, I mean, for CPAs and whatnot, but it doesn't go to criminal. In addition, there's a carve out for tax shelters. Now, there's all kinds of definitions for tax shelters, but if you're messing with tax shelters, you need to be very careful in terms of where the privilege lies, more so than you might normally. We regularly represent entities. When I say we, I mean everybody on this call regularly, I would assume, represents entities, and maybe your client's entity. But when you're representing an organization, it's the organization that you represent unless somehow you agree otherwise. What that means is John Smith, who brought you in because they're the senior VP of something with that company, right? Well, they're not the client unless they agree that John Smith is the client. So keep that in mind, because you may do some things that might not be in the best interest of the individual people, including the referral source who brought you in. So be really, really careful with that. And again, I've been stressing you need to know who you represent and who you don't represent. This is a good example of that. Other ethical duties. You need to be truthful. Okay. But you got the duty of confidentiality, and these things bang into each other. Because sometimes the client, when you find an error, you want to tell, look, we need to tell the service. And they say no. And you come up with a situation where you may have to withdraw. The problem is you start withdrawing, and there's two kinds of withdrawal: the quiet withdrawal and the noisy withdrawal. The noisy withdrawal is, I got to withdraw because my client lied to me, and you really should go and review all those numbers because I don't think you should rely on anything I gave you. Turns out it's all wrong. Or the quiet one, which is, I've got a conflict, something came up with my client, and I need to get out that way. And it's a very difficult balance in terms of how you withdraw. And I run the same thing where I need to get out of, say, a tax court case. And it's tough, but you got to be careful in this situation, because you also need to remember that when a client tells you something and you tell the service that, you're representing that on behalf of the client. So I regularly, when I send something, taxpayer has informed me, my client told me, my client provided this. I try to differentiate between what me and what my office have discovered or investigated, or charts that we drafted, or things that I got from the client, or that I got from, for example, the CPA. Because you're also talking about your reputation, and you want to be really clear, because what we say to the service under that power of attorney, it's as if the client said it. Computational errors. This is kind of an interesting one. The service does sometimes shockingly make math errors. And the issue is, do you have to tell them? And then the question is, what if the client says, don't tell them? There is some authority that if it's in a docketed case, meaning it's before the court, you need to, because otherwise you're telling the court wrong things, versus if it's not a docketed case. I think that this simplifies it a little bit more than it maybe should, because what I often find is when I look at what the error is, I then carry that error through, see if A, it really makes a difference, because sometimes the number might be wrong, but it doesn't matter. Or sometimes it'll be noticed somewhere else, so I'd rather just bring it up. And often when I find that that's the case, it makes it much easier to explain to the client why I'm going to disclose, why I want to disclose it, because they'll probably pick it up anyway, not because of that typo, but because it'll show up somewhere else. So sometimes you can explain things to a client by digging a little deeper and looking at the potential ramifications. Unpublished documents. The Supreme Court sometimes refers to PLRs. The issue has always been the service wants to put out guidance like PLRs, but they're not vetted. Revenue rulings are vetted more, for example. The service lately, when I say lately, at least 10, 15 years, has been putting out these FAQs. And they've been great, except what would happen is, and this was a lot of the offshore cases, they put out FAQs and then they would change them. So every once in a while, we'd print them all. And other lawyers would also that did this kind of work because they changed it. We had to show them because you couldn't find it on the website. Interestingly, the service has come out recently and said, A, they are now going to basically index or database the FAQs that they change. And that if you reasonably relied on it, it can be used as potential basis for avoiding penalties. So I thought that was actually a good thing, but be careful with this basic concept because there is a code section about it. Backdating. I want to talk about backdating. We backdate all the time. When I say all the time, we do. But when we backdate, you can tell a document that I've done that was backdated. Why? Because it's very clear where the notary signed, where it's dated, and what the effective date is. Because if a client says, yes, we made this deal, and then they want you to put it in paper, you put it on paper. That could take a number of months. But that's the kind of backdating that attorneys, I think, ethically can do, because you're simply putting something down in writing to make it clear, right? But you are not ever making up an old date. So that's the end of that. I don't know if there's some questions. I wanted to take just a quick moment in just another minute or two. I've got my little 13 basic concepts, and I just want to run through them really quickly. I got to stress, you need to know and make sure you know who your clients are not, and that the other people know who's the client and who is not. Second, you got ethics and malpractice. There is probably a difference, but keep in mind you've got a duty of competency. In real life, these problems are difficult, they're complex, they're not always readily apparent, and they don't always arise. Everything's fine now. I mean, you're sitting there with spouses and you're doing estate planning, and they're fine until half the marriages end up in divorce, and then they're not fine. There's pressure. I mean, when I went out on my own and somebody for once was actually willing to, with their checkbook, write me a retainer check right there, and I got to pay my mortgage and pay my staff, there's pressure there. Everyone does it is not an ethics rule. If I hear that one more time, this is what everybody does. I don't care. That's not an ethics rule. Taking the client's stuff doesn't create a privilege. There was an old case in Palm Beach County where a fairly prominent lawyer had marijuana in a large envelope marked attorney-client privilege, and they got away with it. There's no general return preparation privilege. Guard your reputation. The tax community is not that big. We talk about people that have in the service. I try to database it. We talk, those of us do controversy work, okay? We talk about them. They talk about us. Clearly they do. Don't inadvertently participate in a fraud. Don't lie, cheat, or steal. Don't talk in the elevator. Watch what you're saying. Carrier test. What would your malpractice carrier want you to do? We spend our whole career oftentimes trying to get this great resume of all our speaking engagements and our writings and all this. A lot of us, myself included, would be better served when we start out, we have a nice clean whiteboard. Try not to smudge it. So that's what I got. Any questions on anything? And I think I kept it to 55 minutes.
Thank you, Michael. I'm not seeing any questions on my end, which is a first for me. Your presentation must have been quite thorough. I personally enjoyed it. So I do appreciate that you took the time to join us today. It was very thorough. I'm going to go ahead and share the CLE code for those who may have missed it in the beginning of the presentation. That is 8549. I'm switching over to make sure we have had no questions come in since the last time I checked. None. And Whitney, unless you're seeing questions on your end, that's a wrap for us. Oh, wait.
Just remember, I was serious. If I close a business tomorrow, if you all come up with whatever typos and misstatements in there, the one that comes up with the most, I will send something.
That's
all right.
funny. Thank you, Michael. Thanks for joining us. Have a great day.